when we broke, I'd made a number of submissions about intelligence, and in particular the issues that related to intelligence sharing. Linked to that is another topic I just wanted to touch on, which is the absence of rules and guidelines regarding the use of intelligence. At the material time, it appears to the victims and survivors I represent that despite various requests and reports that sought a proper set of bespoke guidelines for the management of use of agents in Northern Ireland, there was no formal protocol in place. As was stated in the interim report of the Omagh Inquiry, the use of agents by the security forces in Northern Ireland was not the subject of any meaningful, effective or enforceable legal or policy framework during the course of the Troubles. Similarly, the corporate statement of PSNI states there were no special branch guidelines for Northern Ireland issued by the executive arm of Her Majesty's government, which would include guidance on gathering and managing intelligence in a Northern Ireland terrorist-related policing context. This was an issue repeatedly raised by the IUC with Her Majesty's government, in particular the absence of guidelines and or legislation on agent handling. It's clear that the IUC was unhappy with the situation as it stood at the time, and that it continued to raise the issue with Her Majesty's government. The absence of any rules or guidance governing the use of informers potentially had two consequences. These were, it potentially permitted, firstly, the development of intelligence silos based on intelligence that wasn't shared. In addition, it potentially allowed risks to be taken with public safety, despite intelligence suggesting risk. The submission that risk could be taken with public safety is supported by clear findings in the past that the focus of intelligence handling was on protecting agents, and that as a consequence there was a great degree of tolerance of terrorist activity. For example, it was said in the Omagh interim report that the potential operational priority for security forces was the continued acquisition of counter-terrorist intelligence, and this meant the protection of established agents from compromise. If acting on intelligence about a risk to life might bring its source under suspicion or blow their cover, the intelligence would often be withheld or at least not acted upon. The victims and survivors I represent are not in a position to know on the state of the evidence whether it is arguable that any inaction in relation to intelligence was motivated by a desire to protect state agents. However, the victims and survivors that I represent submit that the evidence regarding prioritising agent safety over public protection is potentially relevant because, firstly, it demonstrates that there is a need to subject any apparent inaction to careful scrutiny. It cannot be assumed that state agents were always primarily motivated by a desire to protect the public. For example, the evidence regarding the handling of intelligence from Kevin Fulton should be considered taking account of the possibility that the protection of Kevin Fulton was seen as a priority. More generally, the material about inactivity or desire to prioritise the protection of state agents demonstrates that there may have been motives for declining to share key intelligence. A further issue linked to intelligence that the victims and survivors I represent would wish to raise is that relating to loss of records. I've already drawn attention to the fact that Kevin Fulton provided intelligence on the 12th of August that the real IRA was to move something north over the following few days. The contact sheet for this meeting and for the meeting on the 23rd of July 1998 could not be located in special branch records. In his response to the Police Ombudsman's report, the former Chief Constable Sir Ronnie Flanagan admitted that due to, and I quote, an unacceptable breakdown in procedure and an administrative error, 2 of the 5 intelligence reports based on information from Kevin Fulton in the period from June to August 1998, were never passed by RUC Force Intelligence Bureau to Special Branch. Although the implication of Sir Ronnie Flanagan's statement was that material had been lost accidentally, there are possible motives for it being deliberately destroyed. A detective sergeant in RUC CID, referred to as W71, who was Fulton's handler at the time of the Omagh bomb, gave evidence to the Smethwick Tribunal that he was informed by Special Branch on the 20th of August 1998, 5 days after the Omagh bomb, and by Sir Ronnie Flanagan during a telephone call, that Keeley, or Fulton, was an intelligence nuisance. That raises issues as to whether Fulton's intelligence was discounted wrongly. If that is the case, records may have demonstrated that, and there was an incentive to withhold them. W71 also gave evidence that I also phoned intelligence through to various departments. It would be surprising if the various departments had not kept records. It's surprising, therefore, that it appears that all records have been lost. The victims and survivors I represent have also raised questions pertaining to the whereabouts of the threat book, which has never been located and which should have contained all information about threats received, including the content of an anonymous phone call on the 4th of August 1998. As noted already, there are good reasons to believe that sensitive material has been withheld in the past from official investigations. It has already been submitted. This means that claims to have provided full disclosure should be scrutinised with care. That is supported by the fact that material has apparently been mislaid in this case in the past. Overall, in relation to intelligence, it's submitted on behalf of the victims and survivors that I represent that the material I've just drawn attention to demonstrates how it's important to investigate with rigour. Firstly, the extent to which intelligence was gathered before the bomb. Secondly, the extent to which intelligence was properly shared. Thirdly, the extent to which there was an appropriate response to that intelligence. That includes whether the response to bomb threats was adequately updated in light of intelligence. A separate topic that is of importance to the core participants I represent is the issue of the linked incidents. The Omagh bomb was clearly not a one-off isolated incident and followed a series of linked attacks in 1997 and 1998. With an increase which was part of an increase of violent dissident Republican activity. While publicly it may have been claimed that these attacks were undertaken by separate entities, the experts would suggest that there was active cooperation and coordination between the dissident groups. It has been suggested in his role as Director of Operations of the Real IRA, Liam Campbell had developed an operational coalition with the Continuity IRA and the INLA. It has also been suggested that following the split, there was evidence of cooperation between the Real IRA and the Provisional IRA when Semtex-based detonating cord and two Irreco detonators were found in a 230-kilogram bomb defused at Bam Bridge and attributed to the IRA. These matters demonstrate the importance of adopting an inclusive approach to prior incidents. Prior incidents should be considered even if not attributed to the Real IRA. It's recognised that the evidence gathering in relation to these earlier incidents is at an earlier stage. The victims and survivors I represent are grateful to the priority that is being given to that evidence gathering by PSNI. At this early stage, the victims and survivors highlight the following matters as being potentially indicative of the fact that earlier incidents needed to be fully investigated or need to be fully investigated by the inquiry and or may demonstrate that the bomb could have been prevented. Firstly, and the issues that arise, we submit, are as follows. Firstly, an issue that I've already raised at other points of these submissions is the issue of whether there was differential policing and or greater tolerance of terrorist violence in Northern Ireland. That means that there is a need to consider whether the prior incidents would have resulted in greater action had they occurred in Great Britain. The concerns that I've just expressed are supported by the fact that in his evidence to the Northern Ireland Affairs Committee, Mr. Baxter, who was in charge of the bomb investigation from 2000, stated that the Omagh bomb might have been prevented had earlier action been taken against those involved in other incidents. He said, and I quote, "There could have been opportunities to arrest this gang after Lisbon, after bombs in May, June and July, even after Banbridge. If we take Lisbon, which is one of the linked incidents, a car bomb, there was an opportunity, had the investigators been given the identities of the bomb team, to carry out searches of the properties or the homes of suspects." He also stated that certainly disruption could have prevented it. Those remarks need to be considered in light of the submissions that I'd already made, that the state had both powers and resources necessary to gather relevant intelligence and then take disruptive action. Another topic that the core participants that I represent would wish to raise is the need for an overall assessment. Depending upon the evidence that is heard regarding the issues, one of the concerns that is raised on behalf of the core participants I represent is whether there was a need for a designated decision maker with responsibility to assess all of the material that may have been available in order to assess what steps needed to be taken to protect the public. For example, was there a need to develop a better response plan to threats such as the threat received in Omagh before the bomb? A further issue that I've touched upon already, but I just want to highlight again, is the issue of differential policing. In his evidence to the Northern Ireland Affairs Committee, Mr. Baxter stated, "I think it's inconceivable on mainland United Kingdom, if you had a series of of bombs happening every week or two, that there would not have been arrests and there would not have been government intervention to ensure that this team was disrupted." One reason to be concerned about differential policing is that, as I've already indicated, MI5, for example, appeared to claim particular success in relation to the disruption of terrorism in London. A further reason to be concerned about this issue is that PSNI's corporate statement appears to suggest that a different approach may have been adopted to the handling of intelligence in Britain to that adopted in Northern Ireland. All of these matters raise concerns that it's submitted are legitimate concerns that need to be examined with particular care. The final topic that I want to raise in this opening is the issue of cooperation with the Republic of Ireland. There is little or no doubt that dissident Republic activity linked to the bomb took place in the Republic of Ireland. That suggests that effective protection of the bomb potentially required the assistance of the Republic of Ireland's authorities. The victims and survivors encouraged the government of the Republic of Ireland, as I've already indicated, to establish a procedure that will enable findings to be reached regarding any failings that may have occurred within the south of Ireland. There is reason to believe that intelligence was known by the Garda but not the RUC. The Omagh bomb investigation team presented a briefing paper to some of the families of the bereaved and injured, the Omagh support and self-help group, on the 22nd of February 2008, which stated, among other matters, firstly, that intelligence material indicated that in November 1997, dissident Republicans discussed the military and police bases in Omagh That information was not passed on to the RUC, and therefore the subdivisional commander in Omagh was not made aware of this information regarding the military bases or his own station. The investigation team assessed that this information should have been passed on to the RUC at the time, bearing in mind the number of terrorist bombs and attempted bombs in 1997. In addition to that, following an operation by the Garda in April 1998 to disrupt a dissident operation, a generalised document was provided to the RUC which was said to lack sufficient detail. More generally, there appear to have been mixed descriptions of the cooperation between the police forces on both sides of the border. The Smithick Tribunal suggests that there was close cooperation at a local level across the border, particularly between police forces in Newry and Dundalk. The Nally report refers to close counter-terrorism cooperation both formally and on a personal basis, and that cooperation was excellent. However, as I've already outlined, in the corporate statement of PSNI, there are statements that suggest preventative material in particular was not shared. Although findings regarding the conduct of Irish state authorities are not a matter for the inquiry, there are clearly findings open to the inquiry. These include whether information of value was received from the Republic of Ireland, whether more could have been done to improve the supply of information from the Republic of Ireland, and whether any information of value received from the Republic of Ireland was effectively deployed. That covers the issues that we want to highlight, or that the core participants I represent want to highlight at this stage. As I've already noted, the victims and survivors I represent are not seeking at this stage to argue that particular findings should be made. The victims and survivors I represent believe that it's important that the inquiry keeps an open mind. However, the victims and survivors argue that it's clear that there are difficult and important issues containing that arise in relation to a range of matters that need to be considered with care. The victims and survivors I represent appreciate the commitment of the inquiry to get to the truth. The range and importance of the issues, though, mean, among other matters, that firstly, it's important that victims and survivors are able to participate fully in the questioning of witnesses, including by asking questions directly. Secondly, victims and survivors' interests are advanced in closed by special advocates. And thirdly, there is full engagement by the Irish government. Thank you. That concludes the opening statement on behalf of the victims and survivors I represent.
Thank you, Mr. Southey.
Thank you.
So would you rise for about 5 minutes, following which we'll hear the final opening statement delivered by Mr. Mansfield, who, as I said at the beginning of yesterday, will be appearing by a video link.
Yes. Mr. Greenie.
So we'll now hear from Mr. Mansfield, who will address you on behalf of the Rush family.
Good afternoon, Mr. Mansfield.
Good afternoon. May I just go slowly to make sure, am I being heard loud and clear, and can everybody see? Is that all right?
You are, yes. Thank you.
Thank you very much. I wanted to also thank you for allowing me to do it this way. As you know, I had an injury, but by the next hearing, I hope to be in person because I prefer that. As you know, I appear together with Nicola Rowntree, and we're instructed by Desmond Doherty on behalf of Libby Rush, who died in this atrocity, her husband, who died later in 2012, and her daughter, Siobhan, who I think may be there today, and her two brothers, Anthony and Andrew. So what I intend to do, as you will see, we've done a relatively short, open, written statement. And I am going to read it, but I will break off occasionally, hopefully not too much and not at length, to incorporate observations on matters that have been put before you yesterday and again some today. And the reason for reading and using this statement in the way it's quite probably different to some of the others is because it does provide for you, and you know a lot already, but it provides for the public a narrative and a genesis, in a sense, of this whole inquiry. And it also explains this particular statement, not only Lawrence Rush's concerns were he to be here to make observations, but also the rest of the family, explains their concerns about observations that were made yesterday and a few more today, as to why they hold these worries, sentiments, and undoubtedly a long-standing, deeply held belief that the truth is the object and they're going to help you and your team. And the Rush family wish to extend their continued gratitude to you, the chair, and the inquiry team for their professionalism, courtesy, and commitment to the inquiry, particularly the last set of hearings, which were commemorative. The terms of reference set out in the key areas of analysis for the inquiry, but the issue of greatest concern to the Rush family, and it is, of course, I have the terms of reference in front of me. I'll come back to them in a moment, but it's quite clear that the core issue for the inquiry is preventability. And that is what is of the greatest concern to the Rush family and requires rigorous investigation, which they're perfectly satisfied you will provide. Often described as the worst atrocity of the Troubles, the Omagh bombing on the 15th of August 1998 altered the trajectory of life for so many. What was set to be a peaceful time in the aftermath of the Good Friday Agreement descended into confusion, chaos, and utter devastation. For the Rush family, and so many others, it was a trauma which shaped so many generations. The grief, the unimaginable loss, has been compounded by the long and arduous path to get to the truth, being met with a wall of silence, the self-protection of the state authorities, the lack of accountability, the closing down of ranks has only further intensified the unresolved allegations which have become corrosive over the past 26 years. I'm turning now to the inquest, which I attended with my instructing solicitor. That occurred in the year 2000. Now, these are important events in terms of not only providing a backdrop, but actually providing you with necessary inquisitive, because you are essentially, it is an inquisitorial process, as you know, inquisitive questions that might need to be asked. And after a section, I'll just stop and suggest where we're going in the light of what has been said yesterday and today. So the inquest happened in the year 2000, so there's been a gap of almost 2 years from the incident itself. The Rush family, Lawrence Rush, adopted a position over 2 decades ago that the bomb could have been prevented. In the year 2000, Lawrence Rush took a stand at the inquest, a lonely figure in the inquest. He asked difficult questions and gently probed at sensitive issues which others sought to shy away from. He was criticized, at times ridiculed. His family lived in a state of fear in case matters escalated beyond words. But he remained steadfast in his suspicions that the full picture was being airbrushed and the truth withheld from the families and the public. This is now the very subject matter that this inquiry is tasked to deal with 2.5 decades later. You, sir, acknowledge the unique and difficult path the Rush family took at the commemorative hearings, describing Lawrence Rush as a campaigner for truth and justice from a very early stage, who sought to cast light on the circumstances surrounding the bombing and tried to learn about previous attacks, what was done and not done. You acknowledge that he was the first to raise some of the questions the inquiry has to determine and not deterred from speaking them loudly and publicly. These questions are still uncomfortable for so many. Lawrence Rush may not have known the full truth about how or why the Omagh bombing happened before he died. That was in 2012. But he had a genuine and honest belief that the state narrative about the bombing didn't make sense. And at the time of the inquest, he was convinced there was more to it. His daughter and 2 sons still view the state narrative about the circumstances of the bombing as illogical. The stance adopted by Lawrence Rush drew virtually no support from any quarter in society. And this had a profound impact on him. He was very much alone in his search for truth and accountability. It was a fact, and of course acknowledged by everyone, the real IRA murdered his wife. They claimed responsibility for the bomb, and that's how it should remain. He had to grapple with this extremely distressing fact, whilst also trying to understand how something like this could have happened without state authorities having any suspicion or worse, actual intelligence about the bomb. He had great difficulty articulating and arguing that he felt that the bombing could have been prevented by authorities of the state, and at times did not want to believe this himself. He challenged himself many times because of doubt and, of course, because of hostility from others. However, ultimately, his determination did not wane, and fueled by the love for his wife and family she'd left behind, he continued to search for answers. Now, if I may, I'm going to pause at that moment, because what I want to do is, just bearing in mind the 2 pages I've read, deal with the question of the response by the state authorities yesterday. And they're really indicating that, we should be sympathetic, which we are, to the difficulties of amassing information. This is an important job. However, it cannot be said that they were not aware. I don't mean the individuals now concerned. I'm talking obviously of continuity here. It cannot be said that government departments were not on notice. The date has been specified today since 2021. I'm sorry, it's much earlier than that. And if I'm trying to put an element of reality in this, once this happened on the 15th of August 1998, are we to imagine that state authorities didn't immediately have meetings? And these meetings are important. I don't know how they all happened. There are various different ways you can have meetings. And the meetings they must have had, which should have ensured the preservation, not, oh, we only got notice yesterday. The state has known since this incident. This was an incident termed, as I've already indicated, the worst atrocity in peacetime. An incident which comes after the Good Friday Agreement. Therefore, there are going to be massive questions, and not just asked within the United Kingdom, but asked within the United States, because of their participation in this, not only at the intelligence level, but at a higher level as well, which I'll come back to a little later. So what they must have done, and if they didn't, I think there have to be concessions fairly soon, and I'll come back to that as well. This all bears on observations made yesterday. The difficulties that they're facing, not, well, in a sense indirectly, but are facing the state, are of their own making. Because if they didn't sit down at that time, or whatever they do, and ask the basic questions. And on this, may I say that the terms of reference are extremely apposite and very well focused. I'm not going to read them all out, but is it to be believed that the state on the 16th of August 1998 didn't ask themselves, and this is the scope part of the terms of reference, and A, the assessment by UK state authorities of the threat posed in Northern Ireland by dissident Republican terrorists from the 1st of December 1997 to the date of the Omagh bombing. This shall include consideration of any change in the assessment. That is absolutely crucial. Are we to believe nobody asked themselves that question? And where are the records relating to that question? And where are they? And if they aren't being preserved, we need an explanation now. And I come back to it under the concessions. These are basic questions that must have been asked then. They don't need to be getting a letter or a writ or a summons before they ask these questions. So the state, not holding them responsible for the bombing in the sense that the real IRA are, but we are saying that they have a responsibility for safety. So if they did ask about these questions, what were the answers? And of course, risk assessment is at the center of this. And it's already been explained what the risk might, terms of the risk might be implied by the European Convention and Article 2 and so on. That's the first question. Second question, these are all basic. The adequacy of measures taken by the authorities to disrupt the dissident Republican terror. Again, you don't have to be at a university level to work these questions out. They're not born from hindsight. If you were sitting there, I was sitting there, and I'd had relatives killed in the high street at Omagh, just as we heard yesterday very movingly from council, you would ask that question. Who did this? Who's claimed it? What have they done before? Where were they? Where were we? I mean, one's trying to introduce an element of realism into this, that there's all very well relying on, well, it's a long time since it happened. Sorry, I'm talking about then. What happened then? What were they doing then about these questions, which are entirely proper? This is the third one, which is obvious again. The adequacy of policies and practice of the UK state authorities, including the police, security forces and intelligence and security agencies, in sharing intelligence. Well, again, it's a question you're bound to ask. Did we know about this? If we didn't know, why didn't we know? Now, these are questions that need to be asked in your inquiry, and I'm absolutely confident, and so are the Rush family, that your council will be asking them and sometimes occasionally maybe you will be asking them yourself. So they've been on notice since 1998. However, it gets more specific in the year 2000. And I can say this because obviously I was there at the inquest. They were absolutely put on notice in the year 2000, not 2021, but 2000. May I just list the issues that arose in the inquest and why Lawrence was isolated in the way I've described. The issues that were one main issue which arose at the inquest is why was the army, we've heard it today from Mr. Southey before me, why was the army not deployed that day? They were there in Omagh. They could have been deployed, so why weren't they? First topic. Second topic, warnings. We went through that. We didn't have all the information that we now had, but we understood there were warnings, including the one on the 4th. So that was an issue then. Intelligence was an issue then, general intelligence, but if there was any relating to Omagh. The possibility of disruption. What we were talking about then was roadblocks, intercepting vehicles, and so forth. Fairly basic. So even if you don't know which vehicle you close the town on, yes, it's a risk. However, the risk here is you've got a dissident group who've made their path very clear over the previous year. So if there's any information coming in and you've got somebody who's inside the organization, you have a precautionary approach. particularly in the aftermath of the Good Friday Agreement when so much was at stake. So these linked incidents were asked about, Banbridge particularly, but ones before that. We didn't have all the information that you now have. So we say, when the authorities say, as they did yesterday, sorry, it's going to take a long time to get there, and actually we've lost a lot of documents anyway, some of which have been outlined today. Horrific, shocking was the description given, that the meetings at a certain level, which were happening regularly, which I suggest were happening on the 16th and possibly the 15th of August 1998, that we don't have the records. Well, if we don't have the records, they better have a very watertight explanation other than, well, we can't tell you. So I paused there because this question of notice and disclosure and concessions, because what I'm going to read now from the statement that we make is the struggle that Lawrence Rush had after the inquest to try and make his point wider than just the questions asked at the inquest. So I'm on paragraph 6 if you're following a copy of it. Baroness Nuala Alone's police ombudsman report dated the 12th of December 2001, so that's 1 year after the inquest, raised some potential issues about the use of and dissemination of intelligence between various agencies within the police at the time. She criticized the police for their response following the event and missed opportunities to properly investigate the bombing. Lawrence Rush had been struggling with doubts and unease about the circumstances surrounding the bomb. This report gave him hope and, in a sense, of vindication for his feelings. He felt that there was finally a light being cast on the actions of the authorities. These findings acted as a catalyst for further investigation. Over the course of the next few years, others began to see what Lawrence had seen from the start, gaps in the narrative, obscured facts, evasive answers, and think that simply didn't make sense. And the Rush family are indebted to Baroness Alone for exposing some of the issues their father sought to bring to the fore and extend their gratitude and respect to her. Given the political landscape at that time and the controversial issues raised, her courage should be recognized and will not be forgotten. I move to the litigation that Lawrence Rush was driven to initiate. You recognize also that Lawrence Rush was the first to issue litigation against the police and the British government. This was not action which was taken lightly, but rather after many legal consultations and after much deliberation. It was the view of Lawrence Rush that this was a necessary step to uncover the truth. Previous inquiries actioned by him and others had resulted in many dead ends, and the family were running out of road. Lawrence Rush litigated in the High Court against the Chief Constable of the PSNI, formerly RUC, and the British government on the 17th of July 2002. So here's another date in the chronology, as it were, whereby the idea that they can only the need to get things together now, when in fact they must have been getting things together much earlier. And here's another stepping stone in that. Some 23 years ago, and 1 year following the publication of the report of the police ombudsman. The cause of action itself, that Libby Rush, this is words taken from the cause of action, Lawrence's wife was murdered on the 15th of August 1998 by reason of the negligence, misfeasance in public office and breach of the statutory duties of the police and the government in their failures in the apprehension, detection and preemptive arrest of members of a criminal terrorist conspiracy, namely the real IRA, who planted the bomb, which led to the explosion in which Libby Rush was murdered. In other words, he was saying, firstly, that the bombing could have been prevented by the relevant authorities, and his wife's right to life was not protected by the state. Secondly, in addition, he said that her murder was never properly investigated. This has always been and remains the Rush family position. The litigation was a difficult chapter in the Rush family history. The mental toll of controversial litigation had an obvious impact on Lawrence Rush. There was fierce resistance by the authorities to information being disclosed into the public domain, and the Rush family feel strongly that this resistance was deliberate to prevent difficult questions being asked. And we would ask this to be borne in mind now in relation to disclosure by the authorities, even at this stage. Lawrence Rush, through this litigation, 2002, presented to the court an alternative narrative. As part of his legacy, we wish to put this formally on the record for the inquiry, reminding everyone that these issues were raised by him 25 years ago. He said from the beginning, and I quote from the pleadings referred to, a proscribed organization, a so-called real IRA, planted a bomb in Omagh. That proscribed organization had been infiltrated by an informer, one Kevin Fulton, who you've heard a lot about today, who fed to the security forces information sufficient to have prevented the bombing. And of course, the documents which have gone missing, mentioned by Hugh Southey moments ago, are particularly pertinent, the one on August the 12th. The so-called missing. The police and government, or one of them, had sufficient quality of information to apprehend the perpetrators or prevent the planting of the bomb. The police in particular failed to take such steps as would have prevented the loss of life by failing to stop the bombers or apprehend them in time or at all, as a consequence of not acting on intelligence to ensure that no car bomb was planted in Omagh on the 15th of August, 1998. Throughout the years of litigation, the Rush family answered every question asked of them. There was much back and forth in the pleadings, and ultimately, the Rush family named a number of individuals and agent handlers in the course of their answers, 2nd of April 2004 and on the 12th of October 2004. The full set of pleadings has been provided to the inquiry, and we would ask you, sir, to analyse these closely. We say there is evidence which is capable of suggesting that the state authorities could and should have prevented the bomb. Another important turning point for the Rush family was the Panorama documentary aired on the 15th of September 2008. Following this documentary, the civil pleadings were expanded as follows. Firstly, that the defendants in the action, through their agents or servants, namely GCHQ Communications Centre at Cheltenham, Gloucester, had contemporaneous intercepts of the bombers' mobile phone communication on the afternoon of the 15th of August, 1998. The said communications centre had actual knowledge of the route of the bombers and their target being Omagh. This information was not acted upon to either apprehend the bombers or put into operation a comprehensive evacuation strategy of Omagh, mindful of the intent of the real IRA, which had demonstrated some weeks previously when a bomb was planted and exploded in Banbridge. The threat and the capacity of the real IRA were known to the police and government in consequence of that previous bombing. The circumstances of the transportation of the bomb to Omagh could not have been more serious, and the defendants failed to react, either in time or at all, to prevent the loss of life to Libby Rush. There was a failure to have in place a clear, precise, and expeditious method excuse me, for transmitting the intelligence received by GCHQ to the police that would have prevented the bombing. The context and timing of these submissions made by the Rush family is important. This was unpopular litigation, and many struggled to support Lawrence Rush. There was a complete blanket denial by the authorities. This, we say, is an important paragraph, because as you will see in a moment, I'm going to pause again for reflection on how the authorities are dealing with it now. Efforts were made by the authorities to strike the litigation out in 2009, the case was described by the police and government as frivolous and vexatious, even unarguable and unsustainable, strong and confronting words for any family to hear. And we are yet to hear a retraction on the part of government, which I'll come to in a moment. The application to strike the litigation out was a private in-camera hearing before the High Court, at which only Lawrence Rush and his legal team were permitted to be present. Later, he was permitted to bring a family friend in view of his failing health and the requirement to travel. There was no public element to the hearings in that initial process, which is in stark contrast to the public and open nature of this inquiry, which we know will be transparent, conducted by you. The initial application was struck out on the 18th of May 2010, and we give the reference. Another setback for the Rush family, and other families perhaps in similar situations might have just given up, but he didn't. But later reinstated on the appeal. 2011, Lord Justice Gillen, in his judgment, did not accept that the position adopted by Lawrence Rush was unsustainable. Towards the end of his judgment, he said, "I've come to the conclusion that it's neither plain nor obvious that the cause of action in this matter has no chance of success. In short, I do not consider that on the pleadings, the case made by the plaintiff is unarguable." By this time, Lawrence Rush was in a nursing home, and sadly his health was deteriorating rapidly. He was comforted by the words of Lord Justice Gillen, but there was still a long road ahead. The litigation had many twists and turns. The process of obtaining disclosure and documentation was tiresome and frustrating. There was inordinate and unjustifiable delay by the authorities in providing information. The Rush family had to obtain a court order to secure discovery. That is why I pause for a moment. The families find it difficult. They want to believe they're going to get cooperation. They're difficult to believe that we're going to get full disclosure, or rather, you're going to get it, because some of it plainly will not be available to us, although we hope and endorse those sentiments that as much as open should be made. The initial writ of summons issued in the High Court was dated 2002, and the Gillen judgment is dated 2011. There was a discovery order for documents dated 2014. It all moved at a glacial pace. Some documents were eventually disclosed, and these have been provided to assist the inquiry. Sensitive documentation was not provided. These civil proceedings were ongoing at the time of the litigation commenced by Michael Gallagher, and together these two sets of legal proceedings complemented each other. Two men, two families, searching for truth and accountability. In the civil litigation, there was a blanket denial of everything pleaded by Lawrence Rush. In the initial statement of claim on the 21st of January 2004, Lawrence Rush pleaded that the defendants, that is, RUC, PSNI, or government, or one of them, had sufficient quality of information to apprehend the perpetrators or prevent the planning of the bomb at Omagh on the 15th of August 1998, which directly caused the death of Libby Rush. In the defence to this litigation, served on behalf of the police and government, dated the 8th of December 2004, the first named defendant, the Chief Constable of Police, further says that he and his servants or agents are not responsible in law for the operational decisions, acts or omissions of the second named defendant, the government, in respect of crime prevention and or crime detection, investigation, and none of the allegations of negligence properly are to be viewed as within his area of responsibility. The Rush family ask you, sir, to conduct a root and branch review of the practices and the oversight of the police and government agencies. Now, this is the kernel of our statement. The Rush family do not seek to criticise or blame officers on the ground in Omagh. And I think none of the families want to do that on the 15th of August 1998, but rather those who had oversight of decision-making, those involved in accessing information, intelligence agents who were making high-level decisions in both police and government agencies. And we know now they were meeting regularly and there was regular contact, but we don't have the record. But those are the people that the family of Libby Rush wish to have questioned, at least in terms of if they're still alive, in terms of the documentation that is available. Who made the decision about the distance of evacuation for the explosion? Who made the decision to deplete the number of officers in Omagh on that particular morning? Who made the decision not to act on intelligence received, not to pass on information? Just a sample of the questions to be answered. The officers who were there on that day were clearly doing their best in horrific circumstances, and the Rush family extend their gratitude to those who tried to help the bereaved and the injured. Lawrence Rush died on the 4th of March 2012. He died without answers. That is a source of great regret for his family. I'm going to pause again at this stage to deal with another observation. And so we take this particular matter, it's not just a procedural matter, it's absolutely vital, we say, to the transparency, the alacrity, and the scope of this inquest. I'm so sorry, inquiry. I was just about to talk about inquest, which overlaps. You asked in the protocol and set out very clearly that you expect State Corps participants to understand and exhibit the principles of the Hillsborough Charter and the Hillsborough Law. You expect openness, candour and transparency. In the event any State Corps participant has identified mistakes or failings going to the terms of reference, 3 of which I've read, there are in fact 9, but I'm not reading them all out, has identified mistakes or failings going to those terms of reference, these must be fully and clearly acknowledged in plain language, cross-referring to the terms of reference and the provisional list of issues. You go on to state, State Corps participants can expect scrutiny of their opening statements in the context of what subsequently emerges. Now, I know your counsel opened these matters, and I wish, on behalf of the Rush family, to endorse them, because both he and I have appeared in previous matters, one of which was the Hillsborough inquest, as opposed to inquiry, and I've appeared in the Grenfell inquiry as well. These are not, it's obvious, and you've said it many times, these are not adversarial, these are inquisitorial processes. And it is extremely important that those who have the materials, which of course is the state authorities here, in fact have had them for 25 years, and they're now saying to you yesterday, it's too early because we haven't heard any evidence. Excuse me, this sounds very much like a process whereby a defendant waits to see what's produced before they say anything. These are not criminal proceedings. And we say the state authorities must be pressed now, not next week, not next year. They must be in a position, otherwise it's more than serious negligence if they don't know where they stand on some of these basic questions. There's quite a lot they can already, we say, concede. For example, if it's going to be missing documents, let's concede that straight away. And that's why something didn't happen, with an explanation. It'll make life for everyone, including obviously yourself, far easier and, of course, far more transparent. And the idea that they don't say anything and they keep their mouths shut until the first witness, we say is a disgrace. That should not happen. And also, may I just add an extra part of the protocol, which we say is important. In the event there are mistakes or failings which a State Corps participant considers can only be acknowledged and closed due to the risk to national security, an account of those failings must be provided in writing to the inquiry legal team in a closed environment at the same time as the open written statement. Any closed document should be accompanied by an application for a restriction order justifying why these concessions cannot be made in open. The chairman expects both open and closed versions of any restriction order applications or clear justification for why no open restriction order application can be made in the closed application, and then upon the receipt of these documents. Now, the question we have on behalf of the Rush family, have you had anybody, or particularly state authorities, providing you? Obviously, we don't want to know what the information is. That's obviously be completely counterproductive. But has there been any closed? We get a hint of it, obviously, with the Ombudsman's statement yesterday. But has anybody else provided you with a closed statement as to why they concede certain things, but they can't, and you've had to, as it were, consider these matters and decide they stay closed or they should be open? So the answer, I'm not asking for an answer, obviously, at this stage, but we say this protocol is extremely important because the problem faced in Hillsborough, which was inquest, in Grenfell was exactly the same. And what happened in Hillsborough was that the learned High Court judge dealing with the inquest insisted that the state authorities make a position statement of what their position, otherwise we wouldn't have known where they were coming from or what they were trying to say or what point was, what they accepted, what they didn't. So they were each made to do that. It was the first one I've known where that actually happened. In Grenfell, it was expected and happened that when the openings occurred, state authorities would make clear what they accepted. And interestingly, what happened in Grenfell was the state authorities accepted certain aspects of responsibility, but the private corporations didn't. But I don't go into it any more than that, other than to say what you set out in this protocol is vital to the lifeblood of this inquiry, that we know now, the families know now, they've waited long enough, what they're prepared to concede. And if the answer coming back within 28 days or the time of the next hearing in July, if they're still unable to do that, then I think there has to be a far more, well, it speaks for itself, may I say, res ipsa loquitur, as they say. So that's the pause I've made. I'm sorry, taking a little longer on that. Coming to the end of this statement. When he died, that's Lawrence Rush, in 2012, the family made a decision to await the outcome of the other legal processes to see if they could make progress regarding the provision of documentation. It was clear from the decision of Justice Gillen, that the Rush litigation could only properly proceed once there was full discovery of documentation. The litigation has been paused pending the outcome of the public inquiry. A public investigation into the Omagh bombing and its preventability, which is what the Rush civil action would have become, is not frivolous, nor vexatious. This establishment of the inquiry is evident of that. The truth about the preventability of the Omagh bombing is uncomfortable. The Rush family view this public inquiry as an important moment in history in trying to uncover the truth and providing some answers for all of the families. They ask you, Mr. Chairman, to now carry the baton they have tirelessly carried 4 years to help them find the answers they've been searching for. The terms of reference are not all encompassing, however, they are sufficiently wide to reflect the concerns of Lawrence Rush. No one knows, Mr. Chairman, where the evidence will lead you, and the Rush family hope that all avenues will be explored. The Rush family, alongside other families, have a lot of information which they have accumulated over the years and hope for maximum participation. May I say just at this stage, the issue raised by Hugh Southey moments ago about special advocates and direct questioning, we defer to the next hearing on the 20th and 22nd July. They ask for as much transparency in open hearings as possible. The Republic of Ireland, the Rush family requests that everyone who's been involved in any way should cooperate fully with the inquiry on both sides of the Irish border. The Rush family had hope that there may be a parallel inquiry in the Republic of Ireland, but that is not the case, and that is obviously supporting the others who have made that same proposition to you. They welcome the memorandum of understanding with the Republic and hope this is sufficiently robust to ensure transparency in the exchange of information across the two jurisdictions. There are clearly many important questions which must be answered by the Irish government relating to the lead up to, time and aftermath of the Omagh bombing. These are amplified because of the overlap of terrorist activity and involvement of identified individuals across both jurisdictions. The following assumptions can be made even at this preliminary stage: that in all probability some element of planning of the bomb was carried out in the Republic of Ireland, that in all probability some perpetrators came from or were involved with individuals from the Republic, that in all probability information which identifies and concerns the perpetrators still exists in the Republic of Ireland, that in all probability there will be information relating to the issues in the terms of reference in relation to the Omagh bombing, which is in the Republic, that in all probability there will be relevant witnesses in respect of the bombing who reside in the Republic. The Rush family say that it is therefore imperative that there is full cooperation on both sides of the border. There is a risk that if the commitments provided by the Irish government and other state authorities in the North are not honoured, this could grind the inquiry process to a halt. The Rush family make a plea that this inquiry does not become a further endurance test of their strength and courage. Each of the bereaved families have suffered enough. In an affidavit on the 18th of May 2005, 20 years ago, Lawrence Rush said, "It's my honest belief that in particular, as a result of all the information contained in the police ombudsman report, with particular reference to the pre-warnings about an attack on Monday, the 15th of August 1998, that the murder of my wife may have been prevented by the defendants. There is significantly more information available now, which the Rush family say supports their belief that the Omagh bombing was preventable. The Rush family are embarking on this chapter of Omagh with positivity and hope. They, along with the other families, have demonstrated remarkable strength of courage. The Rush family hope that this public inquiry represents the beginning of the end of the story of the Omagh bombing. And if I may be permitted, just to add, it's a tiny postscript, but given what is going on globally at the moment, it is important to remember the words of the President of the United States on the first anniversary of the Good Friday Agreement in 1999. And I'm quoting from this very little, I just a little want to quote from this because of its significance in terms of the status of this inquiry and the important role this inquiry plays in the rule of law and adherence to a judicial process. And this is what he said: "As we approach the first anniversary of the Good Friday Agreement, we can all take heart at how far we've come in a year. The agreement has provided the basis for two traditions to work together, both in Northern Ireland and on the island as a whole. For the first time in 200 years," I paused, "I hope that the Republic will respond to what is being said here. Democratically endorsed by an emphatic majority of people in both the North and the South, it gives a unique opportunity for peace and reconciliation in which all the signatories can take pride. And of course, that includes the Republic. It has rightly been acknowledged as an example to the rest of the world how dialogue can bring an end to conflict. These are acute and singular resonance, these words, now, today, in the present circumstance, where the rule of law is being ignored and processes and institutions upholding it are being ignored. What is happening here with your inquiry is continuing exactly what was set out in 1998. And The President went on to reference Omagh in this statement in 1999. Despite the progress, Omagh demonstrated that the peace has not been a perfect peace. He goes on, but the response to Omagh showed that despite the pain, there is deep determination in both the North and the South that peace is the only path. And we say to you, sir, you're part of that path towards truth, because, as has been said so many times, there can be no lasting peace without truth. Thank you.
Thank you, Mr. Mansfield. We hope that you might be able to join us in person at the next hearing of the inquiry.
Yes, I will be there.
Thank you very much. Mr. Greenie.
So I was about to ask Mr. Mansfield to turn off his camera and his microphone, but he's...
Yes, sorry. Straight away.
So that then concludes the opening statements of the core participants. Many important questions have been raised by the bereaved families and survivors over the course of the last 2 days. We expect that no one would expect the inquiry legal team to be in a position to answer all of those questions at this stage. But there are 2 issues upon which we do feel we can provide a degree of further clarification. First, in the course of our opening observations yesterday, we acknowledged the concerns of the bereaved families and survivors about missing documentation. And we made plain the rigorous approach that the inquiry intends to take to any claims that are made that relevant materials cannot be located. In his opening statement, Mr. Kane gave an example of a category of missing documentation. He referred to the fact that it was the inquiry which had identified the relevance of the agenda and briefing papers for and minutes of the security policy meetings. And he identified too that the inquiry had sought these materials from the Police Service of Northern Ireland. Mr. Kane, as we all heard, went on to express the serious concerns of those that he represents about the failure of PSNI to locate any such documents for the years 1997 and 1998. Those concerns, in our view, sir, are understandable, but there is more to the story. The bereaved families and survivors can be assured that, in accordance with the approach we set out yesterday, the inquiry legal team will not simply accept at face value that PSNI cannot locate these documents. Explanations have been sought, and those explanations will be tested. Furthermore, it's important to emphasise that the inquiry's search for these documents has not been limited to a request of PSNI. As Mr. Kane set out, the security policy meetings were attended not only by senior police officers, but also by a range of other senior figures involved in security policy within Northern Ireland. And that range of persons included the Permanent Secretary in the Northern Ireland office. As a result, at the same time as seeking the material relating to the security policy meetings from PSNI, the inquiry also sought that material from the Northern Ireland office. Initially, the Northern Ireland office asserted that it had destroyed those records. The inquiry pressed the NIO hard for an explanation of why those important records had been destroyed and in what circumstances, and the inquiry required further searches to be undertaken for that material. So the upshot is that on undertaking such further searches, the Northern Ireland office has now located most of the documents that PSNI was unable to locate. And the inquiry is actively taking steps to locate the balance. So we hope that this single, albeit small example, will provide reassurance to the bereaved families and survivors, and indeed the wider public, as to the rigour with which the inquiry will seek the documentation it requires for its work. So that is the first issue upon which we are able to offer some clarification. The second issue relates to concessions, a topic upon which Mr Mansfield, of course, has just addressed you. Mr Mansfield has noted that in our opening observations yesterday, we referred to the requirement that state court participants make concessions where they recognise failings have been made. Mr Mansfield noted too that against that background, we said the following yesterday. Quotes, in their written opening statements, the state court participants have not made any such concessions. Today, indeed this afternoon, Mr Mansfield has highlighted that the inquiry's protocol on opening statements says this, quotes, in the event there are mistakes or failings which a state court participant considers can only be acknowledged enclosed due to the risk to national security, an account of those failings must be provided in writing to the inquiry legal team in a closed environment at the same time as the open written opening statement. End quotes. In those circumstances, entirely understandably, the question that has been posed by Mr Mansfield, in effect, is this. Was our comment yesterday that the state court participants have not made concessions deliberately unequivocal? The answer is, it was. The state court participants supplied their opening statements in open. Those opening statements contained, as all have observed, no concessions and gave reasons for that position. It is a fact that no closed opening statements were submitted. So, sir, where we reach is that no concessions have been made. That, sir, is all we propose to say at the end of Chapter 2 of the inquiry's work, save to thank those who have attended or who have viewed the proceedings online, and save to thank the legal representatives for the positive and cooperative way in which they have engaged with this process. And so we believe that finally you have something that you wish to say.
Thank you, Mr Greenie. I would wish to say that I'm grateful to all of the Council for setting out and delivering their respective opening statements. Each has contributed in a helpful and informative manner. Hearing the state court participants explain the processes which they're engaged in will help all of us to understand the challenges which some of them face in providing disclosure to the inquiry. I do not doubt that these challenges are significant. In the case of the Secretary of State for Northern Ireland, he, as a court participant, represents not just his own department, but all of the other departments across government who hold material that is of interest and value to the inquiry. So that adds to the complexities for the legal team he has instructed. It also raises issues concerning two matters in particular. First, the management of the requests from the inquiry. And second, the resourcing needed to comply with those requests. Regardless of the efforts now being made, such as were outlined by Ms. Fee in her opening statement, the fact remains that 2 years have already passed since the Secretary of State announced that there was to be an inquiry. At many times since that point, the progress towards setting up the inquiry and then of trying to move towards evidential hearings has appeared to be frustratingly slow. Difficulties over providing disclosure, of course, impact on the ability to schedule evidential hearings. Many of the complications which make that disclosure such a slow and difficult process are inherent in the task of trying to trace documents and information from so many years ago. Whilst all of us will understand the reality of those difficulties, some of those listening to what was said may have been thinking to themselves that if the various secretaries of state and other ministers involved had not so staunchly set their face against a public inquiry over the very many years and very many times that such requests were made, the problems now being grappled with would not be so acute. Of course, I also recognise that the government departments with whom the inquiry liaises have many other demands placed upon them, and that is perhaps particularly the case for the Secretary of State of Northern Ireland. So I recognise that we are where we are in regard to the timing of the inquiry and the progress to date. I have one observation to make, though, in that regard. Having opposed the setting up of an inquiry so long, there is a plain duty on the Secretary of State and others in government to remedy that now by making available whatever resources are necessary to ensure that full disclosure can be swiftly made available. And I say that not just because of the passage of time. My experience to date has caused me to have some concerns. I have not been convinced that some of those with whom the inquiry has to depend upon to provide it with the materials it seeks have always been in a position properly to engage with the inquiry or to dedicate the necessary resources to those tasks. I therefore trust that after all that's been said over today and yesterday, that my remarks and concerns will be passed on to the relevant ministers and others who manage the responses to the inquiry's requests. Separately, it was, of course, most informative to hear from the family court participants and to learn of the areas which they are most interested in seeing the inquiry explore. For the most part, these areas of interest seem to be shared across the differently represented groups. And again, for the most part, the matters which the court participants wished to see being explored are reflective of what the inquiry legal team has in mind, as is foreshadowed in the provisional list of issues. Having had the benefit of listening to the submissions, I and the inquiry legal team will reflect further on everything that has been said. However, there's one point which I would like to revisit. As was acknowledged in the submissions presented by Mr. Southey, the terms of reference for the inquiry mean that there are limits to what it can consider. That is self-evidently correct. Some of what flows from that boundary to the inquiry's jurisdiction is set out in the list of issues. It is noted there that there are several issues which fall beyond an analysis of preventability. The first of those specified matters is an examination of, and I quote, the UK state's response to the 2 telephone calls made on 15 August 1998 to Ulster Television and the single call made to Samaritan Service, sometimes referred to as the warning calls. The attempts made to evacuate people from the location the bomb was believed to be in, and the emergency response to the Omagh bombing more generally, close quote. As is stated in the list of issues, an analysis of these matters is not within the inquiry's terms of reference. A further aspect of the value which emerged from the opening statements presented on behalf of the family core participants was to learn of the concerns which they harbour. One matter which emerged very plainly was the ability to obtain relevant documentation after so many years have passed. The family core participants have rightly drawn attention to the concerns which they hold over statements made by state bodies about apparent inability to locate relevant documents. The inquiry shares those concerns. What I would say is that while I recognise that the passage of time brings with it challenges, as Mr. Greenie has emphasised, the inquiry will simply not accept statements that what appear to it to be important documents have been destroyed or cannot be found. As the families have pointed out, claims of this sort have bedevilled some previous inquiries. As it happens, I do not even need to look to experience in other inquiries to vouch the importance of assessing such claims with care. I have already seen for myself an example of how assertions that documents have been destroyed can turn out to be unreliable. Where claims are made that documents of importance have been destroyed or cannot be located, material providers can expect such assertions to be subjected to the most rigorous scrutiny. Accordingly, the inquiry will expect to hear detailed evidence as to the nature of the efforts made to locate any such documents and the processes around their storage and retention. And having done so, the inquiry will draw such inferences as seem appropriate in light of the nature and importance of the documents concerned, alongside the quality of any evidence given by way of explanation for their absence. Another area of concern which emerged clearly from the opening statements of the family core participants was that of cooperation between the inquiry and the authorities in the Republic of Ireland. These are understandable concerns, even if some are expressed in more trenchant language than others. I have no doubt that the more strongly worded and sceptical remarks passed concerning cooperation were formulated through the lens of long previous experience. But by way of contrast, I come to these proceedings unburdened by any previous experience of contact, negotiation, or communication with the authorities in the Republic of Ireland. Some may consider that an advantage, others a disadvantage. However, it allows me the luxury of an open mind. I therefore take the various assurances which have repeatedly been made by senior members of the Government of Ireland at face value, and I assume that they are made in good faith. That is the approach which I will continue to take unless and until I am given reason to think differently. So the inquiry will now adjourn until its next hearing, which will take place on Monday, 21st July.